What is a limited liability partnership? Limited liability partnership is a partnership formed and registered under the Limited Liability Partnership Act 2018. See, what is a foreign limited liability partnership? A foreign limited liability partnership means a limited liability partnership formed, incorporated or registered outside India which establishes a place of business in India. Then what is the DPIN? The DPIN means this is an identification number which the central government may allot any individual intending to be appointed as a designated partner of a LLP for the purpose of his identification, such as including director identification number, DIN number issued pursuant to the provisions of Companies Act 2013, who act as an officer under the limited liability partnership. Any partner, designated partner or employee of the LLP or any person in accordance with whose direction or instructions the partners of LLP have been accustomed to act, and any person authorized to accept any service on behalf of a foreign LLP, and a partners of such LLP acts classified as an officer under LLP rules. This is the definition of officer under LLP. Then what is a limited liability partnership agreement? See, this LLP agreement means any written agreement between the partners of LLP or between the LLP and its partners which determines the mutual rights and duties of the partners and their rights and duties in relation to that LLP. Then what is meant by small limited liability partnership, small LLP? Small LLP means a limited liability partnership, the contribution of which does not exceed 25 lakh rupees or such higher amount not exceeding 5 crores as may be prescribed, and the turnover of which as per the statement of accounts and solvency for the immediately preceding financial year does not exceed 40 lakh rupees or such a higher amount not exceeding 50 crore rupees as may be prescribed, or which meets such other requirements as may be prescribed and fulfills such terms and conditions as may be prescribed. This is the definition of small LLP. What is meant by body corporate? See, body corporate means a company as defined in class 20 of section 2 of Companies Act 2013, which includes LLP registered under this LLP Act and limited liability partnership incorporated outside India and a company incorporated outside India, but does not include sole corporation, and a cooperative society registered under any law for the time being in force, and any other body corporate not being of a company as defined under clause 20 of section 2 of Companies Act 2013 or LLP as defined under LLP Act, which the central government may by notification in the official gazette specify in this behalf. This is the definition of body corporate. Can a minor become a partner in an LLP? According to the definition given in section 2Q of LLP Act 2008, partner in relation to an LLP means any person who becomes a partner in LLP in accordance with the LLP agreement. See, the LLP agreement being a contract essentially implies that only a person competent to enter into a contract can be party to it. So under the Indian Contract Act 1872, a minor is not competent to enter into contract. So the answer is a minor cannot be admitted as a partner in an LLP. And then another question is, does a change in the partner of LLP affects its existence, and what are the rights of the LLP? No, a change in the partner of LLP does not affect its existence or rights or liabilities. A limited liability partnership is a legal entity separate from its partners and possesses perpetual succession, meaning it continues to exist regardless of changes in the partnership. So what are the qualifications to become a partner in LLP? So if you see section 5 of LLP Act 2008, any individual or body corporate can act as a partner in the LLP if such a partner is found to be unsound mind or an undischarged insolvent, or has applied to be adjudicated as an insolvent and his application is pending, then the individual cannot act as a partner in LLP. Whether HUF or its karta can become a partner, designated partner in LLP. Answer is no. As per section 5 of LLP 2008, only an individual or body corporate may be a partner in LLP. HUF cannot be treated as a body corporate for the purpose of LLP Act 2008. So therefore a HUF or its karta cannot become a partner or designated partner in the LLP. So whether a trust or a trustee can become a partner in LLP? MCA has clarified that a trust or a trustee representing a trust in case of real estate investment trust, that is the REIT REIT, or infrastructure investment trust, or such other trust set up under the regulations prescribed under the Securities and Exchange Board of India Act 1992, can become a partner in a LLP. So it has been further stated that for the purpose of these trusts, it is not barred for a trustee being a body corporate to hold partnership in a LLP in its name without the addition of the statement that it is a trustee. See how many minimum number of partners are required to incorporate LLP. See, every LLP is required to have at least 2 persons as a partners into partners to incorporate LLP, minimum 2. So what are the maximum prescribed limits and the number of partners on LLP? So there is no maximum limit on the number of partners in LLP. What are the consequences if the limit for a minimum number of partners in LLP has not been maintained? According to section 6 subsection 2 of the LLP Act 2018, if at any time the limit for minimum number of LLP has not been maintained and the LLP carries on the business for more than 6 months while the number is so reduced, then the person who is the only partner of the LLP during the time that it so carries on the business after those 6 months and has the knowledge of the fact that he is carrying on the business alone shall be personally liable for the obligations of the LLP incurred during that period. So what is the minimum number of designated partner that is prescribed under the LLP Act 2008? See, every limited liability partnership shall have at least 2 individuals as the designated partners, among which one of them shall be a resident in India, that is a person who has stayed in India for a period not less than 120 days during the financial year. If all the partners of the LLP are body corporate, then who will act as a designated partner? See, in such case, where all the partners of the LLP are body corporate, or in which one or more partners are individuals and body corporate, at least 2 individuals who are partners of such limited partnership or nominee of such body corporate shall act as a designated partner. Who can become a designated partner? See, there are 2 conditions under which a person can be a designated partner. So number 1, if the incorporation document specifies person who shall be designated partner on incorporation, or it is stated that each partner of LLP shall act as a designated partner from time to time. If the LLP agreement mentions the partner who shall become or ceases to become designated partner. Can a designated partner and partner to be the same person? Yes, the partner in a LLP can be designated as a designated partner in the LLP. However, such designated partner needs to be an individual who are not eligible to be appointed as a designated partner. The answer is a person is not eligible to be appointed as a designated partner if he has at any time within the preceding 5 years has been adjudged insolvent or suspend or has at any time within the preceding 5 years suspended payment to his creditors and has not at any time within the preceding 5 years made a composition with them. So it means suspends or has at any time within the preceding 5 years suspended payment to his creditors and has not at any time within the preceding 5 years or has been convicted by a court for any offence involving moral turpitude and sentenced in respect thereof to imprisonment for not less than 6 months, or has been convicted by a court for an offence involving section 30 of the LLP Act. Is it mandatory for a designated partner to hold a DPIN? Yes. It is mandatory for every designated partner to obtain a DPIN from central government by making an application electronically in e-form DIR 3. Is it necessary to obtain a DIN under the Companies Act 2013 and a DPIN under the LLP Act 2008? No. Where a person is already holding a DIN number, he is not required to make a separate application under a DIR 3 for obtaining a DPIN. And such a DIN shall be sufficient for being appointed as a designated person under the LLP Act 2008. Can a person continue to hold both DIN and DPIN? If a person holds both DIN and DPIN, his DPIN shall stand cancelled and DIN shall be used as a DPIN for the purpose of this LLP Act. One is sufficient. What steps a designated partner take to confirm their appointment? See, a very designated partner shall intimate their consent to become a designated partner to the LLP and provide their DPIN in the Form 9. The LLP is then required to intimate such DPIN to the registrar on Form 4. However, in case of incorporation, the individual who has given consent to act as a partner or designated partner shall file consent in Form FILLIP. What should be designated partner do in the event of change of particulars filed in the DIR 3? If designated partner has been allotted a DPIN or a DIN and in the event of any changes in their particulars, they make an application in Form DIR 6 under the Company's Appointment and Qualification of Directors Rules 2014 to intimate such change to the central government within a period of 30 days of such change. Additionally, the designated partner shall update the relevant changes to the limited liability partners on which he is a designated partner within 30 days of such changes. What are the liabilities of designated partner under the LLP Act 2008? See, a designated partner is responsible for doing of all acts, matters and things as are required to be done by the LLP in respect of compliances of provisions of the Act, including filing of any document, written statement and the like report pursuant to the provisions of the Act and as may be prescribed in the limited liability partnership agreement, and is liable to all penalties imposed on the LLP for any contravention of the provisions. Further, designated partners shall also be responsible for all the regulatory and legal compliances apart from their liability as a partners. See, within how many days the vacancy arising for position of designated director must be filed. See, if there is a vacancy arising in the DP, then within how many days it has to be filed. LLP may appoint a designated partner within 30 days of vacancy arising for any reasons. See, what are the consequences if the criteria for minimum number of designated partner that is prescribed under LLP Act is not fulfilled? See, in that scenario, the LLP and its every partner shall be liable to penalty of 10,000 rupees, and in case of continuing contravention with a further penalty of 100 rupees for each day after the first, during which such contravention continues, subject to a maximum of 1 lakh rupee for the LLP and 50,000 rupee for every partner of such LLP. So these are the main definitions under LLP Act. Thank you.